Hi, thanks for joining us on this video. Because of the horrible things that have been happening as a result of Supreme Court decisions, I have written a fairly lengthy essay to be published on July 4th in the LA Progressive. And I'm going to take today to read that essay to you. So this is going to be about twice as long as my normal sermon. So maybe I should tell those of you who watch on YouTube that this is also available on a podcast on iTunes at Progressive Faith Sermons. So you could listen to it while you were driving down the road if it won't make you steer into the ditch, or possibly as you're going to sleep, although it may keep you from sleeping for 3 or 4 nights in a row. But the podcast is always an option. Our Constitution was written 11 years after the Declaration of Independence. The Revolutionary War followed the Declaration of Independence, but the Constitution was written by some very smart, well-read men who poured their considerable intellect and training into designing a governing document that would guide a new democracy towards a successful future. Thomas Jefferson was actually serving in Paris at the time of the Constitutional Convention, but he wrote a letter to James Madison saying that one generation has no right to bind the following generation, and therefore he suggested that their Constitution should be written in such a way that it literally became null and void after 19 years, so that the next generation could write a new document for their own needs. That, of course, has never happened. The Constitution has been amended many times, but never replaced. I'd like to suggest today that Thomas Jefferson was right, and he was right for reasons that he never would have imagined. The nation in the late 18th century was already deeply divided over the issue of slavery, and there were many literate women who were advocating for an equal role in society and government that they wouldn't get for 100 years. Still, they had no idea how the technology related to combat or to communication would evolve. They hadn't even invented bullets when the Constitution was written, let alone assault rifles. Our generation, in our century, is now bound by a Constitution from a time so distant from our own that it simply does not fit. It now prevents our country from entering the 21st century with the same solutions to problems that our peers in Western democracies have managed very successfully, and which we seem to not even be allowed to consider. I'm going to try to make this fairly brief, but while there is much to be praised in the democracy our founders birthed, there are always ways in which it just doesn't allow democracy to flourish. And more importantly, it has not evolved to meet the needs of our current time. I'm going to point to just a few issues. First, we are the only country with an electoral college. The majority of other countries simply directly elect their head of state, but none of them have an electoral college that makes the decision lopsided as to the number of votes. Our electoral college was once devised as a compromise to give more political power to slaveholding states. It's not just an anachronism, it has become a noose around our necks, electing presidents who did not win a majority of votes, forcing then the majority to live with a president selected by a minority whose views simply don't reflect the majority views of the nation. If we had the kind of elections held in most other free nations of the world, George W. Bush and Donald Trump would have never been president. I'm sure I really don't have to spell this out for you, but Bush appointed Alito and Roberts. Trump appointed Gorsuch, Kavanaugh, and Barrett, and there, my friends, is the conservative Supreme Court majority that now places most Americans at a distance from their own government. I would also add a second criticism of our Constitution, that Supreme Court justices really should not be given lifetime appointments. A lifetime in the 21st century is a lot longer than a lifetime in the 18th century. I think 10 years would be long enough to have one person in such a powerful position. But more than that, and consider, if Clarence Thomas had been forced to retire 10 years after he was appointed, that would have been in 2001, how much better off would the world be right now? It has been suggested by some that we set the term of any Supreme Court justice at 18 years. That seems long to me, but the math works out. If you allow each president during a 4-year term in office to appoint 2 justices, then we maintain the 9 justices, and they at least have a terminal date when they have to leave the Supreme Court, even if they go back to another federal bench. In that way, we maintain the 9 justices, but spread the selection of judges evenly among each president. For example, both Jimmy Carter and Donald Trump were one-term presidents, but Carter didn't get to appoint any Supreme Court justices, and Trump has been allowed to appoint 3, which is exactly what has given us such a lopsided court. The third issue that I will take with our Constitution is the provision that awards 2 senators to every state. Again, this gives a great deal of weight to votes cast in low population states and devalues the votes of people who live in higher population states. Consider, there are 40 million people who live in California. California gets 2 seats in the Senate. But if you added the populations of the 20 lower population states, Wyoming, Vermont, Alaska, North and South Dakota, Delaware, Rhode Island, Montana, Maine, New Hampshire, Hawaii, West Virginia, Idaho, Nebraska, New Mexico, Kansas, Mississippi, Arkansas, Iowa, and Nevada, you still don't come up with a population as large as what is in California. And yet that group of states has 40 seats in the Senate. This is not representative government. This gives tremendous weight to rural and, predictably, much more conservative voters than the people who live in more populous states. And this constitutional flaw, folks, that's how we get some of our most embarrassing members of the Senate, which in turn is how we get some of our most embarrassing members of the Supreme Court. Each senator from California ostensibly represents 20 million voters, while each senator from Wyoming represents just over 200,000 people. This is so wrong that it verges on being crazy. The United States is now primarily governed by a small minority of conservative rural voters who can bind hundreds of millions of people in more populous states to exposure to guns, and they can decide who can get married, or who can you be in love with, when you can have children, and if they follow through with Clarence Thomas's suggestions, even who can have sex with each other. They prevent meaningful environmental reform, as we've seen in their most recent decision about EPA regulations. They're preventing energy innovation and social progress. I know this is a lot to think about in a short amount of time, but honestly, you can find the manuscript of this text on our website or in the LA Progressives edition on July 4. Fact-checked me. I sent this manuscript to doctors and lawyers and psychologists and members of clergy for their review. I think you'll find that all my facts are right. In the past weeks, the Supreme Court has ruled against a 100-year-old law in New York against carrying guns in public. They struck down the 50-year-old precedent of Roe v. Wade, which guaranteed women the right to manage their own reproductive life. They even overturned a 60-year-old restriction against publicly led prayer in public schools. In Clarence Thomas's concurrence with the decision overturning Roe v. Wade, he made it clear that he would like to overturn the 2015 decision that granted the right to same-sex couples to marry, and even to restore restrictions on the kind of birth control methods available to married women and to restrict distribution of birth control methods to unmarried women, and to revoke the right of consenting adults to have sexual relationships. Presumably aimed mostly at gay couples, but it's impossible to be sure. I would remind you that in 1991, Anita Hill, who knew Clarence Thomas very well, tried to warn us about this guy. How can the Supreme Court now be so out of touch with the American people and our shared values? The first and most obvious reason is that the majority has been appointed by Republican presidents, and they were choosing their nominees to curry favor with that 20% of conservative, rural, and religiously bigoted voters that they have to have in order to win an election. Presidents choose jurists to nominate to the court specifically because they have a history of representing the official positions and thinking of the current president's most supportive constituency. And clearly, since it's a lifetime appointment, presidents have tended to nominate younger and younger jurists to extend their personal influence into the future. Again, Clarence Thomas was nominated by President George H.W. Bush more than 30 years ago. The unelected jurist has had more influence on the shape and policies of the United States than the elected President Bush. Now, I'm no fan of identity politics, but in a country as diverse as ours is, you couldn't claim that a court comprised of 9 white men could possibly have the depth and breadth of vision that we now have in our much more diverse court. I was still in grade school when we got our first black justice on the court. I was in seminary when we got our first woman justice. But today our Supreme Court has a fairly representative blend of men and women, blacks and whites, and Latinx members. So hooray for gender and racial diversity. Also, no one can claim that there is a black way of being a jurist if you consider the differences between Clarence Thomas and our soon-to-be seated first black woman on the court, Ketanji Brown Jackson. But when it comes to religion and education, I feel like the court just doesn't look like America at all. The low-hanging fruit is in the realm of education. Everyone on the court has a law degree from either Harvard or Yale, with the sole exception being the recently appointed Amy Coney Barrett, who attended Notre Dame. There are 1.3 million licensed attorneys in America, but less than 0.5% of them attended either Harvard or Yale, and yet they make up 90% of the members of the court. Now, they're both great law schools, to be sure, and yet, are they the only great law schools in America? Is there a bit of intellectual incest going on here? I appreciated my own time at Harvard, but comparing my classes there to my classes at Vanderbilt, I'm not sure you could reasonably say that there was a huge qualitative superiority at either school. But you can say that one of those schools is in the South and one of them is in the North. And you got to know that there are dramatic differences in perspectives in the different regions of our country. For the same reasons that we've tried to make the court a representative blend of races and genders, shouldn't we at least consider things like the region of the country they have lived in and the schools where they studied law? And what is more important, I would say from personal experience, that many of my state university professors in undergraduate school were brilliant. And those professors are much more likely to be in touch with a broader segment of America. If they are brilliant but working in a state university, shouldn't we also consider the influence of these more broadly experienced professors? Still, as with the matter of race, you can't say that Harvard graduates are a legal plenum. After all, Justices Roberts, Breyer, Kagan, Gorsuch, and soon-to-be seated Justice Jackson, they're all Harvard grads. And there's a lot of difference between those 5 people. But still, couldn't we reach out to a West Coast law school or a Southern law school? Again, I have nothing against Harvard and Yale, but couldn't the court benefit from just a little less intellectual inbreeding? When it comes to matters of religious affiliation, I'm finding myself to be very nervously leaning towards thinking that the Roman Catholic influence is so overstated that it is pushing the court towards a view of abortion that sounds more like the College of Cardinals in the Vatican than the values of the American people. About 20% of Americans identify as being Catholic, but of our current 9 justices, 7 of them are Catholic. Only about 2% of Americans are Jewish, but we currently have 2 Jewish justices on the court. Almost half of America claims to be Protestant, but until Justice Jackson is seated, none of our justices are Protestant. Granted, not all the Catholic justices voted to overturn Roe v. Wade, but all of the justices who did vote to overturn this landmark decision were Catholic. Can have a little bit of a caveat for Gorsuch. He was raised Catholic. He's currently attending an Episcopal church with his family, but I think the die may have been cast. Perhaps the larger issue is which ones were appointed by Democrats and which ones were appointed by Republicans. But still, the religious affiliation to be so out of balance screams for consideration, even though the Catholics who did vote to overturn Roe v. Wade were admittedly all appointed by Republican presidents. Now, for the sake of full disclosure, I did publish a very critical article about Amy Coney Barrett, who is a Pentecostal Catholic, when she was first nominated because she seemed to me to have been specifically selected to cast this vote to overturn Roe v. Wade. The article earned me a blistering rebuke from our local Catholic bishop, who for the first time in my life accused me of being anti-Catholic. In my defense, I was right about what I said about Justice Barrett, and given the way I've been feeling the last week, I'm starting to think that the bishop may have been right about me. The Supreme Court, in its most pure form, is intended to make decisions about the meaning and application of the Constitution of the United States. Roe v. Wade was decided on a basis of a right to privacy, which, legally speaking, may have been overreaching in the first place. But let's face it, the Constitution doesn't really offer any more guidance on abortion than the Bible provides guidance in what kind of internet service you should buy. In the matter of abortion, the Constitution becomes little more than the black robes which the justices are wrapped in when they make decisions about what is right and wrong. They use constitutional language, but it's clearly the backdrop of them just deciding what is morally right for America. Abortion, if you think about it, is not really a matter of jurisprudence. It's really a matter of philosophy that deals with ethics, because the primary issue that divides those who are pro-choice from those who are anti-abortion is the question of when a fetus becomes a person, or at least gains the legal rights of a person. Lawyers are ill-equipped to make that philosophical distinction. But then, like everything else in philosophy, philosophers are not good at giving you a clear answer. But the school of thought around ethics, we have to accept, is always changing. We should be able to say with confidence that the debate about the point at which a fetus becomes a person with protected civil rights should not be left up to any religion. But even still, certainly not a minority religion. There's a credible debate to be had, which, oddly enough, never seems to take center stage. What we have seen in the past generation is the manipulation of the political system so that a minority religious view can be institutionalized into our nation's laws. And that, folks, I submit, is something that should never, ever happen in America. Now, ethics cannot be accurately determinative simply by assuming the majority opinion. You can't just poll the public and whatever the 51% vote is, you say that it's right or wrong. But you can't seriously debate an ethical decision without at least consulting and considering what the majority opinion would be. Thankfully, we didn't rely on a majority opinion to end slavery, or for that matter, to even add the first black person or the first woman to the Supreme Court. But it is significant to the degree that abortion laws affect all of us that the majority view among American citizens is that abortion should be a legal option in most cases to all women. It should also be evident that abortion laws are much more relevant to the women of childbearing age than they are to anyone else. Even though the whole matter of birth, standing on its own, is crucial to perpetuating the human race, it is still the woman who is at the childbearing stage of life who must place her life at risk in order to bear a child. You can have an opinion, you can have a strong desire, you may even have a vested or economic interest, but that doesn't always equate to authority. For example, last year, my neighbor informed me that she planned to build a privacy fence that would take in about 3 feet of my backyard. She even added that she already had the approval of the neighborhood association to build her fence on my property. In this matter, my opinion in opposition to the construction of the fence had precedence over my neighbor's personal desires or even my neighborhood association's collective view. Because my property is clearly defined. I have sovereignty over it to the degree that I can prevent my neighbor from building on it. My community still retains a certain amount of authority over my property. I couldn't, for example, put toxic waste in the ground because the community has an important interest in not having either the air or the water contaminated. My neighborhood association could even tell me what size storage building I could have put in my backyard because I just ipso facto agreed to that authority when I bought property in a neighborhood with an association. So you see, there can be many issues about which you have passionate opinions or concrete religious views, but neither of those necessarily give you enough standing in the decision-making process to force your will on someone else. Now, when Jane Doe finds that she is pregnant and she does not want to carry that pregnancy to term, who actually has standing or sufficient vested interest to such a degree that we are obligated to include them in the decision-making process? Now, if Jane is a Catholic, she might want to consider the teaching of her faith community, but still, the church doesn't have sufficient standing any more than I have to vote on what color that young people can dye their hair. Come on, pink, purple, orange, must you? I have an opinion, one that I recognize I should keep to myself. But whether I do or I don't get a vote. In the contract that any of us have with a community of faith, we retain governance of our own bodies, regardless of the opinion of either the faith community as a whole or your priest or rabbi or imam. The Catholic Church may even have a vested interest in the decision because the growth of virtually any religion is predicated more on the birth rate of its members than on its conversion. But still, even if the Catholic Church stands to benefit financially from Jane Doe having a baby, that interest is insufficient to merit a vote in whether she carries her pregnancy to term or not. And for them to even try to extend such governance of their opinions over the majority of Americans who are not Catholic is tantamount to the federal government establishing a national religion, and that is entirely out of bounds in America. The man who provided the sperm in Jane Doe's current pregnancy may have a religious, a philosophical, a family, or even just by reason of the prospect of having to pay child support or adding to their household expenses, may have an interest in Jane's choice. But because the fetus is by necessity attached to Jane's body, the man in this situation can hardly be granted sovereignty, even if his personal finances and other emotional or religious issues are strongly held. Opinions should never become the law of the land. As the Queen famously says in the Netflix series The Witcher, "I bow to no law made by men who never bore a child." We have to acknowledge that the primary concern in the issue of abortion is the pregnant woman. The larger philosophical question is, how did abortion ever become a legal dispute? I'll share with you that I had prostate surgery last summer. And when I made that decision, I didn't have to consult any government or legal authority prior to having it. It was a decision between me and my physician because obviously it's none of your business. Even though that surgery may have some impact on my ability to reproduce, it still doesn't fall under the venue of the government or the public or my listeners online. Why would we have ever assumed that the reproductive life of any woman was a matter calling for a government decision? How was it ever taken from the individual female? But if we let ourselves think how the government or the community might legitimately have a vote in the abortion issue, the only standing is based on our understanding of when personhood is granted to the fetus to be aborted. We would all agree, I hope, that a mother could not legally abort a child on their third or fourth birthday, no matter how much she might regret having given birth. A child post-birth cannot be seen as disposable. Some of the most conservative anti-abortion activists claim to feel that a fertilized egg has as much personhood as a 3-year-old child, making such contraceptive devices as an IUD untenable. Some of the most conservative Catholics even object to the use of a condom, which prevents fertilization because they believe that the sex act either does or does not result in pregnancy and childbirth based on the will of God, and that human actors in sex should not try to intervene upon God's will with either a birth control pill, a condom, an IUD, and certainly not a morning after pill. While that religious view seems to be comprised of balloon juice to me, there are those who sincerely hold this view, and it is apparent religious views are rarely subjected to review by objective facts or critical thinking. Still, it should also be evident that we don't live in a theocracy, and so the truth claims made purely on unsubstantiated religious beliefs about the activity of God or God's values cannot be granted standing in our laws. Any individual is free to make religious values choices about their own reproductive life or for their diet or whether they get divorced or not. But if a religious entity seeks to impose their values on others, you have to remember that's been tried, and we called that time the Dark Ages. However, we do have a real problem in determining when a fetus, which is a potential person, becomes sufficiently an actual person to have a legal right to life, liberty, and the pursuit of happiness. Just as I can, as a member of clergy, reject the standing of any faith community in making that decision, I also cannot, with any degree of certainty, say that a medical doctor, a scientist, a neurologist, a biologist has adequate experience and information to dictate the definition of personhood. These disciplines are a part of the conversation, but they cannot be granted decision-making authority. Again, this is much more the area of philosophy that deals with ethics. But once again, if you're looking for a definitive answer from philosophy, you are setting yourself up for disappointment until you can accept the paradoxical reality that social norms themselves change over time and in different circumstances. Granting that neither science nor religion has the authority to dictate an answer in this consideration, we are left to put the society as a whole on the spot to try to make some collective determination, hopefully at least in consultation with relevant professional insights. We use the term viability to describe the point at which a fetus can survive outside the womb without an umbilical connection to the birthing mother. Now, that point has been moved from the time when Roe v. Wade was passed. It was 26 to 28 weeks. Now it's potentially 22, maybe even 20 weeks, just because of advances in neonatal care. But generally speaking, an unborn child must be umbilically connected to its mother until the 4th or 5th month of gestation. Can a credible argument be made for a fetus to claim personhood prior to the earliest realistic point of viability? Sadly, we know if we just throw that question out to the public, there would be those who would point to signs of fetal pain or to the appearance that a fetus might have in various stages of gestation that makes them look more like a person. Obviously, at 3 months, the fetus doesn't look very much like a human, but a fetus at 5 months certainly does. But could we rationally make appearance the determinative factor in this discussion, no matter how many people want to make it an emotive argument? In philosophy, we call this problem argumentum ad passions, literally an argument from emotions. And it's an appeal that's most often used when there's a lack of factual evidence to support a position. It can be powerful, it can be persuasive, but it's not referenced as a logical fallacy for no reason. How you feel about it is not how it's determined. That a fetus might have a tiny set of footprints early in the gestation might pull at our heartstrings, but this has no relationship to what we mean by personhood. You know, if you let yourself go that far, a newborn baby after 9 months of gestation still doesn't have teeth. It can't walk, it can't talk, it can't get a job, it can't get a driver's license, and yet we would almost universally agree on an infant's personhood. However, we all recognize that even that very, very vulnerable infant has, in most cases, potential to become more recognizable both as a person and as a member of society. While we cannot turn to a physician, a biologist, a philosopher, a priest, or a judge for a definitive answer, sadly, although they have no special expertise, because of our history of legislation and litigation, at some point, a judge will have to render at least a temporary ruling on the matter. And of course, at this writing, the Supreme Court has hinted at a belief that personhood is present in a fetus long before it becomes viable outside of the womb. Most of the citizens of this country simply do not agree with those justices. Hence, we need a judicial system that is guided more by the values of the society than by the minority view of the church they belong to. Now, I think it's important to grant that even the smallest minority opinion on this matter has a plausible demand to be heard at least. The argument from viability has a lot of weight to it because prior to that point, the fetus must be physically attached to the pregnant woman and therefore causes harm or risk to the woman and certainly limits her free exercise of her own life as it would have been if she were unencumbered by pregnancy. A newborn baby is not viable in the sense that they couldn't survive without a great deal of care, but that care is no longer specific to one person's body who has literally been their host. But as noted earlier, while the baby is, by virtual consensus mundi, a person, this status is predicated primarily upon their potential to manifest more and more aspects of personhood over time. But of course, the same can be said in many ways of a fetus in the second or third month of generation. Even for those of us who would not consider that fetus to be a person, still we have to recognize that it has the potential to become a person. It may be something of a stretch, but it could also be said that if you go to a college campus and find a young man and a young woman standing in line to order their Starbucks coffee in the morning, by virtue of the proximity of their reproductive organs, they have the potential to create a fetus that could become a person. Thankfully, even the most conservative religious fanatic would not see the pheromones in the air around this hypothetical pair of strangers as being a person, but from the potential of a mating pair, to a couple engaging in sex, to a newly fertilized egg implanted in the wall of a woman's uterus, there is the possibility of personhood looming in an undefined future. Where the debate about abortion rights remains fluid is precisely at this point. When must we, as a society, claim to have standing in the life of the fetus or person that would override the prerogative of the pregnant woman to terminate that pregnancy or to destroy that life? At what point does the expectant woman's private and personal rights necessarily become subject to the ethics of the surrounding society expressed then, unfortunately, in law? Somewhere between the couple in line at Starbucks and a baby that is now viable outside the mother's womb, there is a cutoff point where a woman can no longer make a personal choice to terminate the pregnancy. The Catholic bishop might put that at the point of copulation, while most of us would put the point closer to the point of viability. The ferocity of the public debate is that for many of the people who are closer to the Catholic bishop's perspective, they don't think there's really much daylight between an abortion clinic and the gas chambers at Auschwitz. But simply holding such an extreme view should not give them permission to dictate social norms to people who don't share that view. We may have to consider them, give them airtime in the public debate, but maybe only slightly more than the weight given to my opinion about what color the kids at the mall should have in their hair. But let's not bring that up again. The thing we must understand about ethics is that it is a moving target. We can consider scientific information, we can weigh the insights of psychology, and in this case, even of anthropology. But in the end, we will be forming a general consensus that I guarantee you will not be permanent. Consider how old a person must be in order to get married without parental consent. In the early 7th century, Muhammad, when he was in his 50s, married a 6-year-old girl. There were those in Muhammad's peer group who objected, and Muhammad did not sexually consummate the marriage until Aisha was 9 years old. But in our universe, that's still horrible. In the late 16th century, Shakespeare plausibly wrote in his fiction play, Romeo and Juliet, about a very powerful romance that was with a 13-year-old girl, whose father's objection was that he had already arranged a marriage for her to somebody other than Romeo. So an acceptable age of marriage 1,300 years ago might have been before a girl was 10 years old. Slightly older than that in Shakespeare's England, but 9 centuries later in the United States, anyone can legally marry without parental consent at the age of 18 in 49 states. In Nebraska, you have to be 19. I'm dying to know what the story is behind that, but right now I have no idea what it is. We may all agree that not very many 18-year-old people or 19-year-old people in Nebraska have any business getting married. But we know that there is some point at which, for good or for ill, people do have a right to make that decision for themselves. And for right now, virtually everywhere, the age is set at 18. Does that mean then that someone who is 17 years, 11 months, and 3 weeks old is completely incapable of marriage, but everyone who's 18 years old is entirely capable of managing a marriage? No, we have just agreed on a number, fully accepting that reasonable arguments can be made for older or younger and that every individual case is different. It's much the same with the legal drinking age. 50 years ago, the United States decided to peg it at 21, but not many countries followed our lead. Most countries set it at 18, a few put it at 16. These are choices made in different cultures for different reasons, but none of those numbers are permanent. Even if people think that they are, I assure you they will change. We have every reason to believe that this is also true in the matter of abortion. For 50 years, women have had a constitutionally protected right to govern their own reproductive life up to a certain point of gestation. And that point has differed from state to state until last week. Now, a woman's civil rights are no longer protected by the federal government when it comes to their reproductive life. That is much less so today than it was for the generation preceding, and it is sad in ways that are difficult for any of us to fully express. While we may have erred, and I'm not saying that we have, but we may have erred on the side of granting permission for late-term abortions at some point, we are certainly now being forced to err on the side of granting personhood to a pea-sized lump of cells. Rights have been taken away from millions of American women by a majority of the members of the Supreme Court whose reasons seem to be largely informed by both conservative Catholic faith and a concern about the wishes of conservative Republican voters, neither of which, I'm suggesting, have nearly as much standing as both the women of childbearing age or the majority of American voters. As previously noted, there simply are no laws that govern a man's body, at least not unless Clarence Thomas gets his way and manages to criminalize gay sex or possibly even sex among the unmarried. There are not laws that govern a woman's body when she is not pregnant. For example, a woman can choose to get a tubal ligation without any legal entanglements. It's only in this matter of pregnancy that we raise this whole matter of whether it's private or whether it's a public civil rights concern. Every society adjusts its collective views on moral norms. In overturning Roe v. Wade, an illegitimate majority on the Supreme Court cut out the public's role in discerning our norms of ethics and forced a standard on the entire nation of more than 300 million people without even consulting us, and obviously without even considering our values. So I conclude that the government of the United States does not adequately represent the people of the United States, and the gulf between the people and the government has become so large that it demands correction. As previously stated, I believe that the best path to this correction would be to provide for direct election of our president, a distribution of Senate seats based on population and not on state boundaries, term limits for Supreme Court justices, and a more equitable division of appointment of justices, granting each presidential administration the same number of appointments to the court. How might some of these matters be addressed? A constitutional convention would be the most effective, and second to that would be a series of amendments to our now 240-year-old Constitution. Either of those options are very difficult because both require a political party or many states to be willing to participate in losing a great deal of their power. A convention could be called for, an amendment can be proposed, with just a 3/4 vote of both houses of Congress or by a 3/4 vote of state legislatures in the country. Low population states, however, are unlikely to give up the power they have through our electoral college system, nor would they happily sacrifice seats in the Senate. Republicans would not vote to change a system which, for 2 generations now, has allowed them to occasionally hold office without popular vote and to exercise minority control over the majority's moral will. Still, a constitutional convention is what I would wish for as the best possible solution. It just has no chance of winning. It has been popularly suggested that the President and the Congress could work together right now to expand the number of seats on the Supreme Court. That is the easiest and quickest way to effect real change on the court, and it has been done in the past. After all, the Constitution never says how many members of the Supreme Court justice we must have. Still, as important as the issues are today, it would also open the floodgates to even more expansion of the court the next time a Republican administration is in the White House and the legislature. Granted, the Republican members of the Senate under Mitch McConnell's leadership stole a nomination from Barack Obama and promised to block any nomination that would come from a hypothetical Hillary Clinton administration. So Republicans have already demonstrated that they are willing to throw ethics to the wind in order to grab power in the judicial system. But expanding the number of seats on the court would be an invitation to partisan interference with the work of the Supreme Court. We want a stable court that reflects America. We don't want to turn it into like an athletic trophy that simply passed from one winning team to the next winning team. The solution that appeals to my mind, but which is rarely mentioned, is the possibility of removing a justice from the court. Even a lifetime appointment can be ended with proper cause. And here I need to ask you to allow me a quick footnote. As previously noted, in philosophy, we've identified several common mistakes of logic and argumentation. We give most of them Latin names because that makes them sound more important. You know, the way advertisers use an actor with a British accent to sound more believable. But one of the most common is called an ad hominem. It means literally attack the person rather than the argument the person is presenting. One of the smartest members of Congress, in my opinion, the member of Congress with some of the best preparation for the job and the passion to raise the most important issues, is the New York Congresswoman, Alexandria Ocasio-Cortez. Millionaire talking heads from Fox to MSNBC try to dismiss her well-reasoned, well-researched, and insightful ideas by simply saying that she's too radical and that the Democratic Party is out of touch with Democratic voters. That is an ad hominem fallacy that any 18-year-old freshman student in philosophy should be able to spot and dismiss immediately. But in these days when critical thinking is an endangered skill, name-calling is often enough to throw the simple-minded off the sequence of an important argument. AOC has been vocal about the obvious need to rebalance the court by removing justices who are guilty of egregious professional failings. And Clarence Thomas is at the top of that list. Initially because of his repeated refusal to recuse himself in cases that directly involved his own wife and her political, albeit probably illegal, political behavior. He has literally voted on cases in which he was attempting to provide cover for a member of his own family. It would be difficult to have a more obvious and unacceptable conflict of interest. For very many reasons, I would say that Clarence Thomas is unfit to sit on the Supreme Court. But this single reason is so obvious that it's not going to take a long investigation. I think give the Congress 5 minutes to look at this, and they could pass articles of impeachment that they then pass on to the Senate. Because our Constitution provides for a federal judge or a Supreme Court judge to be impeached in exactly the same way that we impeach a president. The House has to draft and pass articles of impeachment by a simple majority, and then a trial is held in the Senate. Thomas has violated a fundamental ethical rule for any judge. And so when you're talking about a Supreme Court justice, the only standard for a judgment like this has to be one word: supreme. He needs to go. AOC has also pointed out exactly what I pointed out in a sermon a couple of weeks ago, that Justices Kavanaugh, Gorsuch, and Barrett all lied under oath in their Senate hearings when they were seeking Senate approval to be seated on the court. Each was specifically asked if they intended to overturn Roe v. Wade, and each described that landmark decision as settled law following the principle of stare decisis, which is another important sounding Latin term that means that you let the decision stand because it has already become a part of the country's understanding of what is and what is not law. These three Trump appointees were, we believe, specifically selected to overturn Roe v. Wade. They swore under oath that they would not, and then they did exactly what they had sworn they would not do. If I lied in a job interview, I would have reason to expect to be fired when my employer discovered the unethical deception. Why on earth would we think that a Supreme Court justice should be held to a lower standard than someone who has applied for a job in the food court at the mall? I think that we made a horrible mistake by being so passive when Mitch McConnell literally and unethically stole an appointment from President Obama and held it for Trump. Of course, no drama Obama wasn't much help in beating the drum at the time. Now, I believe, public political pressure must be maintained. All of us must maintain the pressure to impeach and remove Justices Thomas, Kavanaugh, Gorsuch, and Barrett from the court, which at this point would give President Biden the opportunity to appoint 4 justices who will be more responsive to the ethical values of the American people. And as he selects these 4 new justices, I would like to suggest that consideration be given to those who claim no religious affiliation at all, which is at least 1/3 of Americans, but at the very least, justices who are not Catholics, and judges who have law degrees from one of the best law schools in the nation that are not Harvard or Yale and might be a state university. We want a Supreme Court that is comprised of the best educated, most moral, and well-qualified judges, and we need a court that looks like and responds to America.
Thank you for watching our videos. We are entirely dependent on the donations of our listeners and members. We hope that you find this content to be important enough to help us to keep offering these videos to the public at no charge by becoming a regular contributor. Please click on the donate button on our website at www.spfccc.org. Thank you for your support of progressive religious programming.